back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. So today we're going to talk about all of the U.S. immigration changes that have happened in June 2020. And we delayed in making this video because we wanted the dust to settle and then determine exactly how they would impact most of the foreign nationals that are currently inside the United States. So today we're going to discuss 5 of the major changes that has happened in U.S. immigration laws just in the last month. Again, if you're not already subscribed to our channel, please consider doing so. This way, you'll be always updated with all of the latest changes. So again, today is July 4th, 2020. As we celebrate Independence Day, try to empathize not only with the people that were born in the United States, but also people that were raised in the U.S. and consider it their home. So the top 5 major changes to U.S. immigration laws just in the last month in June, I'm going to quickly go over a snapshot of what has happened, and then we'll go into detail on how these changes impact immigration as it applies to you and what you can do to take advantage or to protect yourself against these changes. The first change on June 17, 2020, a federal court concluded that the U.S. Department of State's denial of a U.S. passport to a child who was born in Canada to a same-sex naturalized U.S. citizens via assisted reproductive technology and surrogacy was incorrect. This means that they were allowed to give a U.S. passport to a child that were born of same-sex partners. The second change occurred in June 18, 2020. The U.S. Supreme Court denied Donald Trump's plan to end the Deferred Action for Childhood Arrivals program under the Obama administration. The third change occurred on June 20, 2020. Trump banned legal immigration, denying the issuance of temporary work visas to H-1B, L-1, J-1, and other highly skilled immigrants. On the same day, Trump banned legal immigration by extending his April 22nd presidential proclamation, which was set to expire actually at the end of this month. The 60-day extension bans the issuance of many family-based immigrant visas for, especially children and spouses of green card holders, siblings of U.S. citizens, and parents of U.S. citizens. And then on June 22nd, Trump made it more difficult for asylum seekers who fear going back to their home country because of fear of persecution to apply for asylum in the United States. So, on June 17, 2020, again, a federal court concluded that when the Department of State denied a U.S. same-sex couple the ability to obtain a U.S. passport for their child, a federal court overturned it. And I'm going to discuss today a little bit more about this decision. So when the Department of State argued or denied this couple's case, they said that the child was actually born out of wedlock, which means that the parents were not married when the child was born, and that the surrogacy or the surrogate parent was not the biological parent of the child, and that's why the child is unable to obtain a U.S. passport and join their same-sex parents in the United States. But fortunately, a U.S. District Court for the District of Maryland concluded that the Department of State was incorrect, and they indicated that since the parents who were both U.S. citizens and had resided in the U.S. before the child's birth, the child was by law a U.S. citizen by birth. So if you are a heterosexual couple, you will know that this is very easy for heterosexual couples. If you're abroad and you're visiting and you happen to get pregnant abroad and have the baby abroad, all you have to do is go to the U.S. consulate or embassy abroad and you apply for a U.S. consular of birth abroad certificate. And this document will allow your child to obtain a passport abroad and enter the United States. So many times, people that adopt abroad can also do this. However, as you can see here, the Department of State under Donald Trump tried to deny the same-sex couple the same rights. And fortunately, a federal court determined that that was not legal. So let's move on to the next major change. The next major change occurred on June 18, 2020. The U.S. Supreme Court denied Donald Trump's plan to end the Deferred Action for Childhood Arrivals program. Now, this program is mainly for children that have entered the U.S. before they turn 16. Many of these children were brought in by their relatives, so they had no control over where they were going to go. And what the Supreme Court said was that if you have a GED or if you have a high school education in the U.S., we're going to let you apply for the Deferred Action for Childhood Arrival programs, which does not give you immigration status, but it allows you to not fear being deported, and also allows you the opportunity to work in the United States and become productive citizens, or as I say, foreign nationals in the U.S., not citizens. Now, under the Deferred Action for Childhood Arrival program, the foreign nationals, they pay taxes, and they are not allowed to be on this program if they have certain crimes. And certain crimes include just having a DWI or a DUI, which is driving under the influence or driving while intoxicated. If they have one of these crimes, as well as other crimes, just drug crimes, they're not able to continue on this program, and this program will be stripped from them. So this program is very hard to get into. It's very hard to qualify for. So the U.S. Supreme Court, I believe, did the right thing by not stripping these DACA individuals of their rights under this program. So you might be thinking, when you're reading this, if you have DACA, you might be thinking you're safe, there's nothing for you to worry about, but that's not the truth. That's further from the truth. Let me go ahead and read what Donald Trump and how he reacted after the news broke. In a tweet on June 19, a day after the decision, Trump said, "The Supreme Court asked us to resubmit on DACA. Nothing was lost or won. They punted, much like in a football game, where hopefully they would stand for our great American flag. We will be submitting enhanced papers shortly." So I know that Donald Trump, he really doesn't make a lot of sense when he sends out these little tweets, but what he really means is that he's going to try to end the DACA program. And a link to this article is listed below, so you can read it yourself on MarketWatch. And so besides Trump, what does the U.S. Citizenship and Immigration Service feels about this? And this is where, if you're on DACA, this is where you send your documents in order to renew or apply for the DACA program. So in a statement, this is what the USCIS stated. "Today's court opinion has no basis in law and merely delays the president's lawful ability to end the illegal Deferred Action for Childhood Arrivals amnesty program. Ultimately, DACA is not a long-term solution for anyone." Now you can see that probably they're adhering to Donald Trump's because obviously it's not illegal, because if it was illegal, the U.S. Supreme Court would have just terminated the program. So just think about this for a second. Donald Trump, who is the current president, and also the USCIS that processes these DACA applications, do not want DACA to continue. So think about that before you make the decision that, oh, with the decision with the Supreme Court, I am safe in the country, because I don't think that you are. Now, these are the typical scenarios for people on DACA, and if you have one of these scenarios, you might want to contact an immigration attorney such as our office. That way we can help you determine if there are things that you can do in order to obtain permanent residency inside the U.S. First, if you're a foreign national and you did not have the opportunity to file for DACA in the past, this is a good opportunity for you to apply. So with the Supreme Court decision, it's not 100% clear whether or not people that have not applied can apply. However, many attorneys, including our office, we are submitting brand new DACA applications for individuals who have never applied for the program. So if you did not have an opportunity to apply, you know that you have wasted a lot of time, because if you never applied, you wouldn't have been able to work. You may have not been able to travel under the program, and you wasted a lot of time that you could have obtained, a driver's license and work authorization. So again, if you did not apply for DACA, whether or not be volitional, maybe you were afraid of the government, maybe you didn't have an opportunity to pay the money in order to hire someone. Well, now is the time for you to get up and apply for it. Like I tell everyone that comes to my office, if there is an immigration option for you, you need to take it. The opportunities are not always there. The next major change to the DACA program happens to be if you've previously applied for DACA and it was denied. We are a more experienced law firm. I have been an immigration attorney for over a decade. I know about immigration laws. If you applied for DACA and it was denied, maybe it was your attorney's fault. So if you applied in the past and it was denied, seek out a qualified and more experienced immigration law firm to see if you qualify and whether or not you should submit your documents. Another person that should consider DACA is maybe you're a foreign national who has DACA, but then you committed a crime that terminated your DACA status. So what you may want to do is speak with another immigration attorney, determine if that crime that you committed is really makes you ineligible for DACA, because there are many crimes that you can argue about, and we have successfully obtained DACA for people that have committed certain crimes that they thought made them ineligible for DACA, but it did not. So what you want to do is contact a qualified immigration attorney. That way we can review your file and determine if there is an opportunity for you to reapply for DACA even with a prior crime. Also, if you're a foreign national who has DACA, but you initially entered the country without inspection, now is the time that you may consider filing for advanced parole. Under advanced parole, DACA applicants can travel abroad and then return to the United States lawfully. There has to be certain reasons why you travel, such as medical, education, or work-related reasons. However, if you're able to travel out of the country and back in using advanced parole, in the future, if you wanted to apply for, let's say, a spousal visa, for, a fiance, just different types of things, you'll be able to, because the way the government sees it is that you enter the U.S. lawfully one time, and that makes you eligible to obtain a green card inside the United States. Another change to immigration occurred on June 20, 2020. Trump decided to ban legal immigration. So as you know in the news, Donald Trump has said time and time again he just wants to target people that have entered the U.S. illegally, but that's not the case. If you actually look at the policies that are in place under Donald Trump, he's trying to ban all types of immigration, whether it be illegal or legal. And right now what he did was he denied the issuance of temporary work visas to H-1B, L-1, J-1, and other highly skilled immigrants. H-1B refers to people that are from another country that have a U.S. bachelor's degree or its equivalent. L-1 holders are people that have worked for a foreign company for at least a year, and then they want to come into the United States to help with that business. So these are for employers that have businesses abroad and also businesses inside the United States. And then the J-1 program is a cultural exchange visa program. Is for people with certain skill sets. They come into the U.S. temporarily, usually it's less than a year, in order to acquire U.S. skills to bring back to their country. Now, you may be wondering if you're on one of these types of visas, how it impacts you, and these are the typical scenarios that may impact you. So, if you are a foreign national and you have an expired visa, and you plan on traveling abroad to visit friends and family and obtain a new visa, this will impact you. So this occurs when, I'll give you a typical scenario, an H-1B holder has an expired visa, but they have a valid I-94 that allows them to continue working in the United States. Christmas is just around the corner. They plan on visiting their country for Christmas and visiting their friends and family. And while they're there, they have to apply for a visa because a visa is required in order for them to return to the country, even though their H-1B status has not expired. So again, if you watch our older videos, you know that a visa, the only purpose of it is to enter the United States. So if you have an expired visa, you have to renew it at a U.S. consulate or embassy before you return. So with this Trump's latest proclamation, what he's stating is that if you leave the country and try to apply for a visa, they're not going to issue it. So if you have an H-1B or an L-1 and you intended to visit the consulate or embassy abroad in order to renew it, don't leave the U.S. because if you leave the U.S., they're not going to give you a new visa. Again, this ban that you're reading is for the entire year. So it's only July. So there are 5 more months in this year. So if you are planning on traveling, do not travel until this ban is lifted. So another typical scenario is that a foreign national student that entered the US on an F1 visa and applied for an H-1B lottery. So an H-1B lottery refers to every year the US government allocates about 65,000 H-1Bs, I believe it's 65,000, to just the general public. And if you are a foreign national and you have a U.S. bachelor's degree or a U.S. master's degree or a foreign equivalent, you can apply for an H-1B visa. There are so many applicants every year, and so when they accept applications on April 1st, usually during the first couple of days, maybe a week or two, all of the H-1Bs are accounted for. So what they do is that U.S. and Immigration Services, they randomly select people that are able to apply for H-1B petitions, and then they just reject the rest of the applications. So this is very common. For the last couple of years, there's always been too many people trying to apply for H-1Bs, and there's only a limited number of H-1B visas actually available. So many of these students, what they intend to do is that they plan on, after they finish studying, or if they're on occupational practical training or CPT or OPT, they plan on traveling back to their country, visiting their friends and family, and then applying for an H-1B visa to return to the US. Now, if this is you and this is what you are planning, there is a way out of this. So what you would do is that you would tell your employer to file an amended H-1B petition, and instead of asking the government to allow you to go abroad and obtain a visa, what you will do is that you will ask the US government to allow you to change your status from F1 to H-1B on October 1st, 2020. So this option is not available for everyone because this will mean that you would have to maintain your F1 student status until October 1st, which is the first date that you can go on H-1B status. It's kind of confusing for people that are not trying to apply for an H-1B. But if you are a student and this confuses you, it must mean that the employer or the employer's attorney did not effectively communicate this with you. But what you can do is always talk to your designated school official, because every school has a DSO or designated school official, and they're responsible for ensuring that foreign nationals maintain their current immigration status. So if you are a student and you have questions about this and your employer is not very knowledgeable about immigration laws, you want to speak with your DSO in the international department to make sure that you are adhering to all of the immigration requirements while you're in the US. The next typical scenario involves a foreign national that recently got married abroad. Now, if you're on H-1B or L-1 visa, you know that your spouse can come into the country on an H-4 visa or L-2 visa and join you in the US. Now, with this new change that Donald Trump has instilled, what it's stating is that your spouse and children, they will not be able to join you in the US because their visas are not going to be issued. Again, this ban is until the end of the year, and there is very little or anything that you can do about it. So unfortunately, if you got married or your spouse traveled abroad to visit friends and family, and their H4 or L2 visa has expired, they are out of luck. So unfortunately, this ban does impact you very much, and I don't even know what to say. It's beyond words that Donald Trump is banning those individuals from joining you in the US. So another type of scenario is a foreign national who is planning on applying for an H-1B, L1 or J1 visa. So if you are abroad, this ban really hurts you because they're not issuing any visas abroad. No principal applications for visas and no dependent visas. If you're in the US, at least you have an opportunity, if you can maintain status the whole time, change your status, extend your status. But if you are outside of the US, you're out of luck. You're just going to have to wait until this ban ends next year, and then you'll be able to apply for a visa, hopefully. Again, Donald Trump has a habit of extending these bans. So I would not get your hopes up. And unfortunately, the U.S. employer does not have to pay for your expenses while you're abroad. So this is something that's unfortunate, but you just have to deal with it. So another thing that happened in June 2020 was that Trump extended his presidential proclamation that he made in April 22nd. Now, with this presidential proclamation, he said that in order to protect against COVID-19 and also to help with the unemployment rate in the U.S., they're banning the issuance of family-based immigrant visas. And again, this is legal immigration. People that have properly filed their case, they were informed that if they filed their cases, paid the fees, and waited, it could be, 12 to 14 years for a sibling petition. They waited all that time. They should be able to obtain a visa later on and come to the U.S. Well, under this proclamation, Trump is basically saying, yes, you did it the right way, but no, we're not letting you in. Now, again, this proclamation occurred on April 22nd, and what had happened was it was supposed to end on June 22nd, which is 60 days. However, Trump extended this ban on 6/20/2020, and now is in effect for another 60 days. In my opinion, Donald Trump again is going to extend this ban in the future. Now, I can't predict the future, but just based on his prior record, he loves to extend these bans, and it's going to delay the process if you are doing this type of case. So if you read it here, it says that the ban applies to, there's certain exceptions. Like if you are a U.S. citizen, it does not apply to your spouse or your children that are under 21. Now, if you are a green card holder, it does apply to your spouse and children. And if you are a U.S. citizen, it also applies to siblings and parents. So, unfortunately, this ban is crazy to me because if you have parents that are older and they are worried because of COVID-19, maybe COVID-19 is even worse than what it is in the United States, which is kind of hard to believe since we are so bad right now. There's nothing you can do about it. Your parents are stuck outside of the U.S. So it's hard for me to speak about this ban because I have so many clients that are impacted by this ban. All I can tell to our clients is that we will help you until this ban is lifted. However, if you don't have an attorney, you want to keep up with the latest changes because there may be an exception to your particular case. Maybe your case is of national interest and your relative should come to the U.S. earlier, and there should be an exception for the ban. However, if you don't have an attorney, this is something that you need to research yourself because an attorney is not going to know the specific facts of your case. The next major change is that Donald Trump on June 22nd is making it more difficult for people to apply for asylum. Again, asylum is when a person fears persecution or they fear being attacked in their country, and they flee and they run to the U.S. So you can imagine that people that enter the U.S., they don't have a lot of belongings. If you're fleeing your country, usually you have the clothes in your back, the money in your pocket, whatever you're wearing, and that's all you have when you're fleeing your country. Now Donald Trump is making it more difficult for asylum seekers. And how is he doing this? So Donald Trump is now requiring applicants to wait 365 days or 1 year instead of 150 days to obtain employment. So what this means is that usually people that enter the US either legally or without inspection, and then they apply for asylum, they only have to usually wait 150 days before they can apply for any type of work permission. Now under Donald Trump, he's stating that they have to wait an entire year. Think about this. If a person is fleeing their country, all they have is the clothes in their bags and the money in their pockets, and they're here with their families, do you know how hard it is for them to survive? Not being able to work for over a year? Well, this is what Donald Trump wants to happen to them. Another thing that Donald Trump has done is that he is ending the 30-day processing time frame for initial employment documents. So again, prior to Donald Trump's change, an asylum applicant would have to wait 150 days after applying to apply for employment, and then after that, they have to wait another 30 days to receive the employment authorization document. Now, under Trump, he's saying that you have to wait over a year, and we are not even going to guarantee that you will get your employment document within 30 days. Again, think about how crazy this is. The US needs to protect our friends and our neighbors who are experiencing persecution in their country. Imagine if this was you. You lived in China and you did the right thing. Maybe you uncovered a government conspiracy. You let the government know, you did a protest, and then the government started sending people to try to kill you and your family, and then you escape to the US, and the government, the country that you're escaping to is telling you, you know what, you can stay here, but we're not even going to let you apply for asylum until a year later. And we're not going to let you get the employment documents quickly after you qualify for it. This is not humane. They are expecting asylum seekers to seek shelters. They're expecting them to live on the streets while they are in fear. I mean, they just escaped persecution. This is beyond words. It's unconscionable to me, but this is what the US government is doing to asylum seekers right now. Another thing that they're doing is that they are limiting the employment authorization validity period to a maximum period of 2 years. Now, if you do not have an asylum case, you may not know this, but there are hundreds of thousands of asylum cases on backlog. Some of these cases have been pending for more than 5 years because the US government does not have the resources to interview everyone or to deport anyone. So it's a slow process. Some cases are just given a decision very quickly, maybe in 1 or 2 months. However, a lot of them, again, hundreds of thousands of them haven't been decided. And again, if the government only allows them 2 years of employment authorization, this means that they may be in the US for years without being able to work. Think about this. This is crazy. And instead of allowing them to work, allowing them to pay taxes on what they are illegally doing, essentially the government is saying that we don't want them to work legally inside the US. So if they work illegally, they're not going to pay taxes. And this is going to hurt the US economy. Also, Trump is saying that he wants to automatically terminate employment authorization when an asylum denial is affirmatively final. This is ridiculous because as most immigration attorneys know, when a case is denied by an immigration officer for due process reasons, the foreign national is given an opportunity to go before an immigration judge in order to make sure that the officer did not make a mistake. So right now, what Donald Trump is saying is that after it's denied by one single immigration officer whose decisions are not reviewed, or not appealable, we're going to automatically get rid of your authorization to work. Now, if you're at home and you don't have any dealings with asylum laws, just know that these new rules are ridiculous. And if this does not shock your conscience, there is definitely something wrong with you. So please don't call our office, and definitely I'm not friends with anyone who is agreeing to, who feels that this is not a big issue. And this actually ends our presentation today. However, when I was recording this, I just thought of something else. There is another major change that happened in U.S. immigration laws. Right now, the Trump administration is proposing that they end the I-601 program. So what the I-601 program or I-601A program states is that if you entered the U.S. without inspection, or if you overstayed your visa, you're able to obtain an I-601A waiver. And this waiver is not guaranteed. So what this waiver states is that if you have a parent, if you have a spouse that is a U.S. citizen or a green card holder, you haven't committed certain crimes, and all you did was either enter the U.S. without inspection or overstayed your visa, we'll allow you to apply for a waiver. And if you get that, we'll give you permission to leave the U.S., obtain a visa, and return to the U.S. without being subject to a 3 or 10-year bar. So right now, the government is actively trying to get rid of this program. And this program is very close to the I-601 and the I-212 waiver programs. The I-601 is for people that are not currently in the U.S. but have previously entered the U.S. illegally or without inspection or overstayed their visa, and now they're in their own country. And the I-212 program is for people that have currently inside the U.S. or abroad that have been previously ordered deported. And with those two programs, you can apply for a waiver. Again, the qualifications are very similar to the I-601A program, but these people just happen to be abroad. Those programs as well may be coming to an end. So if you are qualified to apply for a 601A waiver program or an I-601 or I-212, know that your time is limited. So if you have spoken with our office or another office and we told you that you qualify for this program, I've always told clients that, look, immigration programs are not a guarantee. They're not guaranteed to always be there when you need it. So if you have qualified for these programs, you need to take it upon yourself to start on it now because it may not be there. And the government has already posted online that they're trying and actively trying to get rid of the I-601A provisional waiver program. So again, these are the changes that have happened in just June 2020. You can see that immigration is changing very fast. So make sure that you keep your ears wide open so you can hear all of these new changes. Thank you for watching Winning Law. Again, I'm attorney David Nguyen, and on behalf of our firm, we want to extend our wishes to everyone that's watching, and we hope that you and your family are safe and protected during this pandemic.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.